This is Chapter 58, Real Estate Commission, Subchapter 58A, Real Estate Brokers, from the North Carolina Real Estate Commission Rules, Section .0100, General Brokerage, A.0104, Agency Agreements and Disclosure. A. Every agreement for brokerage services in a real estate transaction and every agreement for services connected with the management of a property owners association shall be in writing and signed by the parties thereto. Every agreement for brokerage services between a broker and an owner of the property to be the subject of a transaction shall be in writing and signed by the parties at the time of its formation. Every agreement for brokerage services between a broker and a buyer or tenant shall be express and shall be in writing and signed by the parties thereto not later than the time one of the parties makes an offer to purchase, sell, rent, lease, or exchange real estate to another. However, every agreement between a broker and a buyer or tenant that seeks to bind the buyer or tenant for a period of time or to restrict the buyer's or tenant's right to work with other agents or without an agent shall be in writing and signed by the parties thereto from its formation. A broker shall not continue to represent a buyer or tenant without a written, signed agreement when such agreement is required by this rule. Every written agreement for brokerage services of any kind in a real estate transaction shall be for a definite period of time, shall include the broker's license number, and shall provide for its termination without prior notice at the expiration of that period, except that an agency agreement between a landlord and a broker to procure tenants or receive rents for the landlord's property may allow for automatic renewal so long as the landlord may terminate with notice at the end of any contract period and any subsequent renewals. Every written agreement for brokerage services that includes a penalty for early termination shall set forth such a provision in a clear and conspicuous manner that shall distinguish it from other provisions of the agreement. For the purposes of this rule, an agreement between brokers to cooperate or share compensation shall not be considered an agreement for brokerage services and, except as required by Rule .1807 of this subchapter, need not be memorialized in writing. B. Every listing agreement, written buyer agency agreement, or other written agreement for brokerage services in a real estate transaction shall contain the following provision. The brokers shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. The provision shall be set forth in a clear and conspicuous manner that shall distinguish it from other provisions of the agreement. For the purposes of this rule, the term familial status shall be defined as it is in GS 41A-3 (1B). C. In every real estate sales transaction, a broker shall, at first substantial contact with a prospective buyer or seller, provide the prospective buyer or seller with a copy of the publication Working with Real Estate Agents, set forth the broker's name and license number thereon, review the publication with the buyer or seller, and determine whether the agent will act as the agent of the buyer or seller in the transaction. If the first substantial contact with the prospective buyer or seller occurs by telephone or other electronic means of communication, where it is not practical to provide the Working with Real Estate Agents publication, the broker shall, at the earliest opportunity thereafter, but in no event later than 3 days from the date of first substantial contact, mail or otherwise transmit a copy of the publication to the prospective buyer or seller and review it with him or her at the earliest practicable opportunity thereafter. For the purposes of this rule, first substantial contact shall include contacts between a broker and a consumer, where the consumer or broker begins to act as though an agency relationship exists, and the consumer begins to disclose to the broker personal or confidential information. The Working with Real Estate Agents publication may be obtained on the Commission's website at www.ncrec.gov or upon request to the Commission. D. A real estate broker representing one party in a transaction shall not undertake to represent another party in the transaction without the written authority of each party. The written authority shall be obtained upon the formation of the relationship, except when a buyer or tenant is represented by a broker without a written agreement in conformity with the requirements of paragraph A of this rule. Under such circumstances, the written authority for dual agency shall be reduced to writing not later than the time that one of the parties represented by the broker makes an offer to purchase, sell, rent, lease, or exchange real estate to another party. E. In every real estate transaction, a broker working directly with a prospective buyer as a seller's agent or subagent shall disclose in writing to the prospective buyer at the first substantial contact with the prospective buyer that the broker represents the interests of the seller. The written disclosure shall include the broker's license number. If the first substantial contact occurs by telephone or by means of other electronic communication where it is not practical to provide written disclosure, the broker shall immediately disclose by similar means whom he or she represents, and shall immediately mail or otherwise transmit a copy of the written disclosure to the buyer. In no event shall the broker mail or transmit a copy of the written disclosure to the buyer later than 3 days from the date of first substantial contact with the buyer. F. In every real estate sales transaction, a broker representing a buyer shall, at the initial contact with the seller or seller's agent, disclose to the seller or seller's agent that the broker represents the buyer's interests. In addition, in every real estate sales transaction other than auctions, the broker shall, no later than the time of delivery of an offer to the seller or seller's agent, provide the seller or seller's agent with a written confirmation disclosing that he or she represents the interests of the buyer. The written confirmation may be made in the buyer's offer to purchase, and shall include the broker's license number. Let me just read that sentence again. The written confirmation may be made in the buyer's offer to purchase and shall include the broker's license number. G. The provisions of paragraphs C, D, and E of this rule do not apply to real estate brokers representing sellers in auction sales transactions. H. A broker representing a buyer in an auction sale transaction shall, no later than the time of execution of a written agreement memorializing the buyer's contract to purchase, provide the seller or seller's agent with a written confirmation disclosing that he or she represents the interests of the buyer. The written confirmation may be made in the written agreement. I. A firm that represents more than one party in the same real estate transaction is a dual agent, and through the brokers associated with the firm shall disclose its dual agency to the parties. J. When a firm represents both the buyer and seller in the same real estate transaction, the firm may, with the prior express approval of its buyer and seller clients, designate one or more individual brokers associated with the firm to represent only the interests of the seller, and one or more other individual brokers associated with the firm to represent only the interests of the buyer in the transaction. The authority for designated agencies shall be reduced to writing not later than the time that the parties are required to reduce their dual agency agreement to writing in accordance with paragraph D of this rule. An individual broker shall not be so designated and shall not undertake to represent only the interests of one party if the broker has actually received confidential information concerning the other party in connection with the transaction. A broker in charge shall not act as a designated broker for a party in a real estate transaction when a provisional broker under his or her supervision will act as a designated broker for another party with a competing interest. When a firm acting as a dual agent designates an individual broker to represent the seller, the broker so designated shall represent only the interest of the seller and shall not, without the seller's permission, disclose to the buyer or a broker designated to represent the buyer, 1, that the seller may agree to a price, terms, or any conditions of sale other than those established by the seller, 2, the seller's motivation for engaging in the transaction unless disclosure is otherwise required by statute or rule, and 3, any information about the seller that the seller has identified as confidential unless disclosure of the information is otherwise required by statute or rule. L. When a firm acting as a dual agent designates an individual broker to represent the buyer, the broker so designated shall represent only the interest of the buyer, and shall not, without the buyer's permission, disclose to the seller or a broker designated to represent the seller, 1, that the buyer may agree to a price, terms, or any conditions of sale other than those established by the seller, 2, the buyer's motivation for engaging in the transaction unless disclosure is otherwise required by statute or rule, and 3, any information about the buyer that the buyer has identified as confidential unless disclosure of the information is otherwise required by statute or rule. M. A broker designated to represent a buyer or seller in accordance with paragraph J of this rule shall disclose the identity of all of the brokers so designated to both the buyer and the seller. The disclosure shall take place no later than the presentation of the first offer to purchase or sell. N. When an individual broker represents both the buyer and seller in the same real estate sales transaction, pursuant to a written agreement authorizing dual agency, The parties may provide in the written agreement that the broker shall not disclose the following information about one party to the other without permission from the party about whom the information pertains. 1. That a party may agree to a price, terms, or any conditions of sale other than those offered. 2. The motivation of a party for engaging in the transaction, unless disclosure is otherwise required by statute or rule. And 3. Any information about a party that the party has identified as confidential, unless disclosure is otherwise required by statute or rule. O. A broker who is selling property in which the broker has an ownership interest shall not undertake to represent a buyer of that property, except that a broker who is selling commercial real estate as defined in Rule .1802 of this subchapter, in which the broker has less than 25% ownership interest, may represent a buyer of that property if the buyer consents to the representation after full written disclosure of the broker's ownership interest. A firm listing a property owned by a broker affiliated with the firm may represent a buyer of that property so long as any individual broker representing the buyer on behalf of the firm does not have an ownership interest in the property, and the buyer consents to the representation after full written disclosure of the broker's ownership interest. P. A broker or firm with an existing listing agreement for a property shall not enter into a contract to purchase that property unless, prior to entering into the contract, the listing broker or firm first discloses in writing to their seller client that the listing broker or firm may have a conflict of interest in the transaction, and that the seller client may want to seek independent counsel of an attorney or another licensed broker. Prior to the listing broker entering into a contract to purchase the listed property, the listing broker and firm shall either terminate the listing agreement or transfer the listing to another broker affiliated with the firm. Prior to the listing firm entering into a contract to purchase the listed property, the listing broker and firm shall disclose to the seller client in writing that the seller client has the right to terminate the listing, and the listing broker and firm shall terminate the listing upon the request of the seller client.